All right, welcome everyone to the deep dive. Today we've got a deep dive that's, it's presented by Safety One Source, and we're really going to be focusing on some crucial information for, well, all of you safety individuals out there, right? And really anyone who is, looking to really up their knowledge on construction site safety.
Yeah, absolutely. We've put together a pretty substantial collection of official OSHA interpretation letters.
Oh, wow.
And our aim here is to kind of sift through all of this wealth of information and distill it down really to the key points that are going to be most relevant to your work, as you try to make sure that construction environments are safe.
Exactly. So the big question that we're tackling, and this is coming straight from these OSHA communications, is what are some of the most the biggest OSHA requirements and interpretations when we're talking about, safety training, right? Making sure communication is effective. First aid protocols, what are those? And using equipment properly on construction sites. So we're not just going to be like listing rules.
Right.
We're going to be figuring out how does OSHA actually put these rules into practice?
Yeah, and for safety professionals, we know that staying current on all of the regulations can sometimes feel like it's just this huge uphill battle.
Right.
And so what we're trying to do with this deep dive is to really give you guys clear, actionable, intelligence that's coming directly from OSHA.
Exactly.
Which should hopefully help you make more informed decisions and beef up your safety programs.
I like that, beef up those safety programs. Okay, so let's just dive right in, to one of the questions that we see come up all the time in construction safety, which is about language.
Mm-hmm.
Is it actually a requirement for every single person on a construction site to be, proficient in English in order to communicate about safety? Does everybody have to speak English?
Well, an OSHA interpretation letter, this one's dated July 26, 2010, gives us a pretty straight answer.
Okay.
And it's no. There's not actually a specific OSHA standard that says, across the board, everybody on a construction site needs to be, proficient in English to talk about safety.
Okay. So that might surprise some people.
Yeah.
So then what, if English isn't the be all and end all language for safety, then what does OSHA say is really important to make sure that everyone can understand safety training and instructions?
Yeah, well, that's really the heart of how they interpret this.
Mm-hmm.
OSHA really emphasizes that all safety training, all the instructions, they've got to be communicated effectively, and they have to be understandable to the employees who are on the receiving end of that information.
Mm-hmm.
And it doesn't matter what language is being used.
Right.
Their position, as they laid it out in a policy statement back in 2010 that's referenced in this letter, is that terms like train and instruct, those terms inherently mean that you're presenting information in a way that makes sure that the people who are getting that information
Right.
are actually able to get it. So, it's really about whether or not the communication is actually working.
Right. The effectiveness of the communication.
Rather than saying, it has to be English.
Right. Exactly.
Yeah.
That makes total sense when you think about it, because at the end of the day, what you really want is for everybody to get that safety message, right?
Right.
And understand it.
Absolutely.
It doesn't matter what their first language is. Yeah.
Exactly.
Yeah.
And the letter often goes on to clarify this further. It says that any reliable system of communication that actually achieves this understanding, that gets people to understand what's going on, that's acceptable. Doesn't have to be English.
Yeah.
And they even, to back this up, they actually offer a ton of resources in Spanish.
Oh, okay.
So, for those of you who are looking for these materials, you can find them pretty easily. They're on OSHA's website.
Okay.
And you just go to the compliance assistance section, click on the Hispanic tab.
Okay.
And this really shows you OSHA's being proactive here. They're trying to make this safety information accessible to a diverse, group of workers.
Yeah, I like that. That's a great tip for our listeners,
Yeah.
knowing where to find those resources.
Absolutely.
That can be really helpful for safety professionals who are working with teams where people speak a lot of different languages.
Yeah.
Okay, so let's shift gears a little bit here and think about multi-employer construction sites, right?
Mm.
So these are more complicated, right? Because now you've got all these different companies involved.
Right.
So the question is, who is actually responsible for making sure that safety training happens properly, when you've got this kind of environment?
Yeah, this definitely causes a lot of confusion,
Yeah.
on a lot of different projects.
Sure.
And we've got a letter from February 6, 2012, that speaks to this directly.
Okay.
And this one focuses on how OSHA's multi-employer citation policy actually applies to certain training standards.
Mm-hmm.
So we're talking about standards like 1926.2 over B1 and B2.
Okay.
These lay out kind of general safety and health stuff. The requirements for programs that are meant to prevent accidents.
Right.
And then there's 1926.21 B2, and this one zeroes in on the employer's responsibility to actually teach employees how to spot unsafe conditions and avoid them.
Okay, so it's not always as easy as saying, oh, whoever directly employs the worker who needs the training, like they're the only ones who are responsible, right?
Exactly, yeah. This multi-employer citation policy, it creates different categories of employers
Okay.
who can actually be held accountable for safety violations,
Uh-huh.
and that includes, when training isn't done right.
Okay.
So these categories are, you've got the creating employer, who's the one who actually creates the hazardous condition, the exposing employer, their employees are the ones who are exposed to the hazard. Then you've got the correcting employer. This is the one who has the responsibility and the means to actually fix the hazard. And then the controlling employer, who's got kind of general supervision over the whole site, and they've got the power to make sure that everybody's following the rules.
Okay, so that helps to break it down. So even if a company, their own employees aren't the ones who are like directly in harm's way, they could still be held responsible if they fit into one of these other categories, right? Like if they created the hazard or if they're, in charge of site safety overall.
That's exactly right.
Okay.
Yeah, and the letter actually gives an example. It points out that a general contractor, who's contractually obligated to provide safety training to subcontractors, they could actually get cited by OSHA if it turns out that training wasn't good enough.
Wow.
So the big takeaway here for safety people is that on a multi-employer site, responsibility for training, it's not always just one person's problem, right? It can be shared depending on, what each employer's role is and what they're responsible for.
Right. Yeah. That's really important for our listeners to think about. Their safety oversight might go beyond just their own employees, depending on how the project's structured. Okay. So let's say you've got a situation where there's a hazard on a construction site, but there's not like a specific OSHA rule that covers that exact thing, right? Like, how does OSHA approach those kinds of situations?
Well, that same February 6, 2012 letter gives us a good example of that.
Okay.
It talks about the danger of people slipping on glue, like glue that's been spread on the floor before they install carpet.
Okay.
And the question was, do you have to have warning signs or barricades for something like that?
Right. What did they say about that?
So they said that there isn't a specific OSHA standard that says, in this exact case, you've got to have signs or barricades.
Mm-hmm.
But the General Duty Clause, which is Section 5A1 of the Occupational Safety and Health Act, that kicks in.
Okay.
And in this clause, it's kind of broad. What it says is that employers have to make sure that the workplace doesn't have recognized hazards, things that are causing or could cause death or serious injuries.
Right.
And this idea of, dealing with hazards, even when there's not a specific rule, it connects to another really important thing in workplace safety, which is making sure that we can respond effectively to emergencies.
Right. So even if there's not like a very specific rule in the book, if there's a known hazard and it could hurt somebody, employers still have to do something about it, right?
Right.
Under this general duty clause.
Exactly.
Okay.
But with this glue slipping hazard, and thinking about this multi-employer citation policy, OSHA actually drew a distinction.
Okay.
They said that in this particular scenario, under the general duty clause, only the exposing employer,
Okay.
meaning the employer whose workers are the ones who could actually slip on the glue, they're the ones who could get cited.
Gotcha.
And they also pointed out that if an employer decides to use warning signs as part of how they're controlling this hazard, those signs need to follow what's laid out in CFR 1926.200, which covers signs and tags for safety and health.
Okay, yeah, that's an important detail to understand, who can actually be cited under the general duty clause,
Right.
especially in these multi-employer situations. Okay, let's move on now to something that's always a huge concern on any construction site, right?
Right.
And that's emergency medical services and first aid.
Yeah, this was really the main focus of a really detailed letter that came out on March 2, 2005.
Okay.
And it tackled a bunch of key questions related to first aid on construction sites. One of the first things it clarified was that OSHA right now doesn't have any specific construction standards in the works that would require the use of automatic external defibrillators, or AEDs.
Okay, that's interesting, especially because you see AEDs popping up more and more.
Yeah.
In all kinds of places, right?
Yeah.
Public, private.
Yeah.
So that's interesting that there's not a specific rule about that yet.
Right. The letter also touched on the question of protecting emergency medical technicians, EMTs,
Okay.
who might decide, on their own to bring an AED to a construction site. And they referenced Section 11C of the OSH Act, which, that provides whistleblower protection.
Okay.
But they were very clear that, whether or not disciplinary actions or threats against an EMT for bringing an AED,
Yeah.
whether that would be a violation,
Right.
that really depends on the specifics of what happened.
Right.
And it would have to be looked at by the OSHA regional or area office.
Okay. So it's not like there's automatic protection in that situation.
Right.
It really depends on the details and what the employer actually did.
Right. Exactly.
Okay. What about unions, when it comes to deciding who the first responders are on a construction site? Is that something that falls under OSHA's rules?
Well, OSHA's authority generally doesn't reach into those labor relations issues.
Yeah.
So the letter specifically says that, the OSH Act doesn't deal with whether or not a union has the power to say, these specific members are going to be the first responders.
Right.
That kind of thing is considered something that the employer and the union have to agree on, outside of what OSHA directly regulates.
Okay, so then what are the actual requiremements from OSHA when it comes to having people who are trained in first aid on a construction site?
Right. Well, the standard, which is 29 CFR 1926.50C, and this one's about medical services and first aid.
Okay.
It says that you've got to have someone there who has a valid first aid training certificate,
Yeah.
and they have to be able to provide first aid if there isn't an infirmary, a clinic, a hospital, or a doctor that's reasonably accessible.
Okay.
And by reasonably accessible, they mean in terms of time and distance. And OSHA has actually given some additional policy guidance to clarify what that means, what reasonably accessible and near proximity actually mean in different construction settings.
Okay, that makes sense. Now, what about on those really big projects, or projects that have multiple stories? Is having just one person who's trained in first aid, is that usually enough to satisfy OSHA?
Well, this gets addressed in 29 CFR 1926.50B, which says that employers have to make sure there's prompt medical attention available, if somebody gets seriously hurt. And the letter mentions the CMC Electric court case, which was really important because it stressed that you have to minimize any delays in getting medical treatment, especially when it's a serious injury, because even a few minutes can make a big difference.
Right, of course.
Yeah.
So just having one designated person, to handle first aid, that might not be good enough if they can't actually reach an injured worker quickly enough, right?
Yeah.
Especially on a site that's really spread out, or if it's a multi-level building.
Exactly. And the letter goes on to explain that, whether one first aider is enough on a big site or a multi-story site where you've got workers all over the place, that depends on a few things, like whether the elevators are working, how good the communication systems are on site, and how long it would reasonably take for that first aider to get to anybody who's injured. So the main thing they're looking at is, can you get medical attention to someone quickly when they need it?
Right. Okay. What about the first aid kits themselves? Like, are there specific things that OSHA says employers have to put in them besides just the basic first aid supplies? Like, do you have to have certain medical equipment?
So according to 29 CFR 1926.50D, employers have to make sure that those first aid supplies are easy to get to, and the kits have to have the basic stuff you need for common workplace injuries.
Right.
But the letter clarifies that medical equipment, the kind of stuff that goes beyond those basic supplies, that's not actually required by OSHA. And then even if you have employees who have, more advanced medical training, like if you've got paramedics on staff,
Right.
that doesn't mean you suddenly have to have all kinds of fancy equipment,
Yeah.
beyond that basic first aid kit.
So just because you happen to have people who are, highly trained in medical stuff, that doesn't mean you have to set up a mini hospital on site, right?
That's right. The basic requirements for that first aid kit, those stay the same.
Okay. All right. Let's switch gears again and talk about respiratory protection.
Okay.
What are the main rules when it comes to using respirators on construction sites?
So the requirements for using respirators in construction, which you can find in 29 CFR 1926.103, are basically the same as the ones you see in OSHA's general industry standards, which are at 1910.134.
Okay.
And the big idea here is that respirators, you have to use them whenever they're necessary to keep employees from breathing in air that's contaminated, or if there's not enough oxygen in the air. It's not like, every single person in a certain trade, like all electricians, automatically have to wear one.
Right.
It really depends on, what the specific hazards are in their work environment.
Okay.
And something really important to note is that it's the employer's responsibility to provide training, both the initial training and then annual training, on how to use respirators correctly, how to take care of them, and also to make sure that every employee who needs to wear a respirator gets fit tested properly.
So it's about the hazards, not the job title.
Exactly, yeah.
Yeah, that makes sense. Okay, let's go back to the general duty clause for a minute. We talked about it earlier with the slip hazards. Does this clause, does it have anything to say about like qualifications for construction foremen? Like, does it require them to have certain qualifications just in general?
So question 9 in that March 2, 2005 letter, that one specifically deals with that. And OSHA clarifies that there's not like a blanket requirement under the general duty clause that says every foreman on every construction site has to have certain qualifications no matter what.
Okay.
But it's really important to remember that some specific OSHA construction standards do require people to be designated as competent or qualified to do particular tasks. And those standards will usually explain what those terms mean in that specific situation.
Right.
And the letter also reminds us that employers have a duty under 1926.21b2 to train all employees, and that includes foremen,
Right.
on how to spot and avoid unsafe conditions on the job.
So even though there's not like a universal rule about qualifications for foremen under the general duty clause, they're still expected to know about safety and be able to, lead their crews in a way that keeps everybody safe.
Absolutely.
Okay, so kind of related to that, does the general duty clause say that an employer has to have a designated first responder on every single job site that has, 5 or more employees?
Well, according to the letter, the answer to that one is no.
Okay.
The rule about having a first aid person readily available, that's tied to whether or not there's a good medical facility nearby, like we talked about, 1926.50c.
Right.
It's not just based on how many employees are on the site.
Okay.
So if there's a clinic or a hospital that's reasonably close in terms of time and distance, then that specific standard doesn't necessarily say you have to have a designated first responder, even if you got a lot of people working there.
Okay. So that's an important distinction,
Correct.
right? It's about making sure people can get medical care quickly. It's not just about having a certain number of people who are trained, right?
Right.
Okay. Let's talk about how workers can call for help in an emergency.
Okay.
What does OSHA say needs to be in place for emergency communication on a construction site?
Well, Section 1926.5050A, the Pravi OSF, that's pretty clear. It says that you have to have a reliable way to call for medical help, and that has to be available on every construction site. And if the local emergency number, 911, if that doesn't work in that area, then you have to post the phone numbers for doctors, hospitals, ambulance services,
Right.
and those have to be posted where everybody can easily find them. And this is to make sure that if something happens, people can get help fast,
Right.
and they don't have to waste time trying to find those numbers.
Makes sense. Now, the letter also, it briefly talks about what happens if an employer has a rule that says you can't use cell phones on the job.
Yeah.
And they basically say that usually a rule like that wouldn't be considered a violation of OSHA standards.
Right.
So, you've got to have a way to call for help, but OSHA's not necessarily saying that every single worker needs to have their own personal cell phone.
Right.
Okay, let's talk about safety when it comes to specific types of equipment.
Oh, sure.
Let's start with lasers. What kind of training do you need to use a level 1 laser in construction?
So we've got a letter from September 21st, 1992 that addresses this. 29 CFR 1926.54, the AA.
Yeah.
That does say that employees who install, adjust, and operate laser equipment, and that includes level 1 lasers, they need to get trained.
Right.
But the standard itself doesn't actually say exactly what that training has to include.
Okay.
So in those cases where a standard doesn't give you the specifics of the training, OSHA says you should look at the general safety training requirements, which are in 1926.21b.
Right.
And how OSHA interprets this is that employers need to give operators instructions that follow what the laser equipment manufacturer recommends.
Okay.
And make sure that the employees understand the dangers of the laser and how to prevent exposure to it.
Makes sense.
They also suggest looking at the American National Standards Institute, or ANSI, Standard Z136.1, 1986, just for some extra guidance on laser safety training. And then it's considered best practice for this training to be done either by somebody from the manufacturer who knows what they're doing, or by somebody within the company who's been designated to do it and who's knowledgeable about this stuff. And of course, it's always a good idea to keep records of this training.
So the key takeaways here are to follow the manufacturer's instructions and to make sure that whoever's doing the training is really an expert on laser safety.
Exactly.
Okay. What about excavators? You know, those have a swing radius that can be really dangerous.
Yeah, for sure.
What does OSHA have to say about protecting workers from that?
So this is definitely a major safety issue.
Right.
And OSHA's talked about it in a few different interpretation letters, including one from February 23, 1994, and another one from January 16, 2003.
Okay.
And OSHA considers it a serious hazard, the possibility that a worker could be hit by that rotating part of the excavator.
Right.
It's a well-recognized hazard in the excavation industry. And since there isn't a specific OSHA rule that spells out exactly how to protect against this, OSHA relies on a combination of things. There's that general training requirement from 1926.21b2, which says employees need to be trained on how to spot and avoid unsafe conditions.
Right.
And then there's the general duty clause. So OSHA uses both of those to make sure employers are taking steps to prevent workers from getting into that swing radius while the excavator is running.
So what are some examples of things that OSHA says employers should do to prevent these kinds of accidents?
Yeah, well, the letters, they give a few examples. One is to put up physical barriers, to clearly mark off the swing radius.
Right.
Another is to use those bright warning lines so workers can see them and know to stay away. Or they could implement other, procedures that are recognized in the industry to keep people out of that swing radius. And then that January 16, 2003 letter, it also makes it clear how OSHA distinguishes between backhoes and excavators. So they point out that backhoes usually don't have that continuously rotating top part,
right,
whereas excavators do.
Okay.
And that's important because the hazard of the swing radius, that's really specific to equipment that has that rotating upper structure.
Yeah, that's a crucial difference to keep in mind when we're planning for safety, right?
Sure.
Understanding how those two types of equipment actually work differently. Okay, let's talk about fastening tools. There are different kinds used in construction.
Yeah.
So are the training requirements the same for those gas-actuated fastening tools as they are for the more traditional powder-actuated tools?
Well, a letter from December 24, 2005 that clarifies this, section 1926.302E. It specifically says that you have to provide training for each specific type of a powder-actuated tool that's being used, and that training has to follow the guidelines from a specific ANSI standard.
Okay.
But that very specific training requirement, it doesn't automatically apply to those fuel-actuated or gas-actuated tools.
Gotcha.
So for those types of tools, you still got that more general training requirement from 1926.21b2.
Okay.
Which means that employers, they still have to teach their employees how to recognize and avoid unsafe conditions when they're using gas-actuated tools, and they have to make sure their employees know the safety rules that apply to how they operate those tools.
So even though there's not a rule that says you have to have model-specific training for those gas-actuated tools like you do for the powder-actuated ones,
right,
employers still have that basic responsibility to make sure they're used safely, and that means providing training, right?
Absolutely, yeah.
Okay, let's talk about how we actually deliver safety training.
Okay.
Can employers just rely on videos You know, can they just show videos to meet OSHA's training requirements?
Well, we've got an interpretation letter from August 3, 1999 that tackles that question head on.
Okay.
And while 29 CFR 1926.21, it doesn't come right out and say that training has to be interactive or hands-on, the overall goal of the standard is to make sure the training is effective.
Right.
And OSHA's position is that just relying on videos, that might not always be effective.
Okay.
Especially when you're talking about, hazards that are specific to a particular site.
Right.
Or when you're teaching people how to operate equipment.
Right. Right.
Because it can be hard to know if employees really understand and can do what they need to do if they're just watching a video, right? They need a chance to interact, to ask questions, to actually try things out.
Right. To apply it.
And even though 1926.21 doesn't specifically say you have to give tests or written exams, employers are supposed to do what makes sense to make sure employees have actually learned the information.
So videos can be a good part of a whole safety training program, but they shouldn't be the only thing you do.
Yeah.
Especially when people need to have practical skills and knowledge that's specific to the site, right?
Absolutely.
Okay, let's talk about training for skid steer loaders. These are used a lot in construction.
Yeah.
So what are the training requirements when they're being used for earth moving?
So a letter from November 5, 2004 gives